The conversation continues in Kenya's biggest conversation. This is the Situation Room for our audience online and on radio and TV as well on KTN Home. Karibuni Sana in the studio this morning. Nduoko, Siti Muga and Wanjiro Gikonyo as we continue to look at issues in the country. One of the big ones was the Gazette notice by the president yesterday. And look, it's been 1.5+ years of asking the president to appoint the judges as recommended by the Judicial Service Commission. And there's been a tussle. There's been a back and forth here or there. What exactly is going on? It would seem like a direct contravention of the Constitution because he was not appointing these judges and it was within his purview. It was his then responsibility to do just so. And many times an argument had been used that the president was not doing this, and there was a lot of fault that was found with him for not. Well, now he's done it. And it's been done. Albeit that not the entire number of judges whose names were presented then have been appointed. But 34 out of 40 were appointed yesterday, and the remaining 6, according to this notice, did not meet the threshold for the courts onto which then they were going to sit.
According to the statement attributed to the president.
According to the statement attributed
to... And yet the JSC had found them fit.
Yes.
Okay, carry on.
The JSC had found them fit, and that's why they had gone through the process, and that's why those names now were delivered. Yes. Right? Now, according to the president, according to this statement by the president, according to the Gazette by the president, it was that these 6 had not met the threshold. Now, the details of that threshold or what more they were being asked to meet, that we are not privy to at this moment. We saw it blow up almost immediately after it was announced. And there are certain sections of the legal fraternity who said, no, we were not asking for 31 or 34. We were asking for 40. The recommendation was that the 40 names that were presented by the JSC should have been instituted as judges in the different courts. We were not asking for some, and then you pick and choose which one you want. And I believe the term that immediate former Chief Justice David Maraga used was that we don't want cherry picking. This is what we have brought forward. We've gone through the process. We've deliberated. We've done the due diligence. Now, this is our recommendation. Go ahead and do it. And now we see that some names have been left out. We've already heard from the chair of the LSK yesterday. No, we are not interested in 34. We're interested in 40 out of 40. And that in itself is stepping out of your bounds once again and doing things the way in which you want to do them. And this is the action that has been attributed to the president by way of this Gazette notice. All right? So it seems as though, again, even with the
BBI case,
even with now these
every
appointments,
every
there's a problem.
2 cases a week. Because there was the KMC Defense Forces contempt ruling and actions. You know, why would Okay, first of all, the last president of Kenya who was able to appoint judges was Moi under the old constitution. The new constitution changes that paradigm, gives that responsibility, the recruitment responsibility to the JSC. Why would the president want to interfere with the work of the JSC? That's the question we want to ask.
All right, so there's some whys that we will hope to open up a little bit today, rather in this hour. And joining us on the line today to be able to open up this conversation a little bit is the chairman of the International Commission of Jurists, Kelvin Mogeni. Kelvin, good morning. Hello.
Good morning. Are you good?
Yes, we are good, Kelvin. Asante Sana for joining us this morning. How are you doing?
I'm trying. Disappointed.
You're disappointed. Could you tell us, first of all, the reason for your disappointment?
We're setting a very bad precedent, and I think this started from the time of Judge Willie Mutunga. We had a similar situation where some judges had not been appointed, and the cherry picking was done. Of course, eventually all the judges were subsequently appointed. But this is the president that is coming out bad, and what is causing distress among the legal practitioners and the country as a whole is that there have been several orders of the courts, ordering the president to comply with certain provisions of the Constitution. but it seems like he chooses which orders to comply with and how to comply with them. And this cherry picking is an issue that has become a big issue in the country right now, and I don't think it's serving Wanjiku well. But all said and done, and right now we have got two schools of thought, and which is causing division. And of course, the divide and rule is an issue that is become now the new agenda of the part of the executive. Because of the 34 appointments, the bulk of those who have been appointed, let me say 100% of the practicing lawyers, are included in the list of those who have been gazetted. One school of thought is that these practicing lawyers who have now been gazetted as judges, for the last 2 years, have not known whether they were lawyers or judges. And they have not been in practice.
Yes.
Of course, in contradistinction to the serving judicial officers and judges who were either to move to the Court of Appeal or to the High Court. They were still serving in the positions they had been and earning salary continuously. The ones who have been left out, the 6 who have been left out, are serving judges of the High Court. There is a message that is being sent that, if you make decisions against the executive, then the executive will come hard on you.
Are you then saying, Kelvin, are you then saying that these 6 who've been left out, it is beyond the reason of not meeting the threshold, and it could be another message that is being passed here?
They're already serving as judges. The threshold they already met, because that is the threshold of being appointed as a judge of appeal has already been met. The issue that was being raised, the president, in not so many words, had indicated that there were issues they raised with the JSC about the suitability of these persons in other modes other than legal qualifications. They were either dossiers or other things they may have had. We have not cited any of that. It has not been either presented in the many matters that are pending before court. There are cases even which have been made before court stopping the executive from these cherry-picking issues. He has not complied with that. But what he is saying, and this as I said, is a trend that has been set, because the constitution provides a process of appointment. We have the nominations by the Judicial Service Commission, and the ultimate appointing authority is the president, because the president appoints.
Yes.
The same way, when a bill is sent from Parliament to the president to assent to it. So that is our constitutional process. Because when the president is not comfortable with the bill of Parliament, he will send it back with an executive dossier as to why, or reasons why he's not accepting that. And there is a limit in terms of time within which that has to be done. Now, we have had 2 years where nothing has been said of the reasons why the president is not either appointing or rejecting or sending back or giving a recommendation back to the JSC why he thinks there is an issue with any of them. Because, these are a document that is growing. The Constitution of Kenya 2010 is a document that is growing. It's evolving. The areas where we may not have had concrete issues, the court has made pronouncements on them. We should have seen that as a codified area, because courts are pronounced on those areas on what the president should do when nominations have been sent to him.
Yes.
And these are an issue because, for the position of CJ and the DPCJ, that has to go to Parliament. And, Parliament can reject. It does not mean that once you have been sent to Parliament, Parliament will have to accept. There is a provision for that. So here we have, the president has accepted 34.
Yeah.
There are no reasons for the other 6. We have not seen a communique. We hear that the president has sent the 6 back to the JSC for other consideration.
So we're saying other considerations aside from those that they were presented for initially.
Yes.
Okay.
I don't know what that could be, because the 6 were not in the initial list that had earlier on been presented to the JSC. I don't know whether the inclusion of these other persons was in relation to either pronouncements that have been done in the interim period or otherwise. Let me not question the philosophy behind the president's decision.
Well, then allow us to question it for you. Then.
Right. So okay.
What I'm trying to understand.
Yes.
Is there a rationale for him to send back names of any of the nominees from the JSC for reconsideration by the JSC? And I believe that this is an issue that must be determined and resolved. It was done during Judge Mutunga's time. I know Judge Maraga was requested to do this cherry picking, and he rejected it completely. And of course, the judiciary, we know that as Kenyans, we have been incapacitated in terms of numbers. So many Wanjikus are suffering because of the sluggish movement in the judiciary right now. But we need to remember, if you remember during the legislative appointments in the 50s,
yes,
the numbers that have been given to Jaramogi and others, they said, look, we know we are entitled to many. We'll go in and fight for the others. And they actually went in and fought for the others and succeeded.
Is that what you think is going to happen now? I mean, just from what you're looking at now, Kelvin, is that we've already seen a rejection of this. It's either all or nothing, and that has come out from the LSK, for example. And there are others within the fraternity who are saying, okay, so now what are we doing? We're headed into a stalemate. Does that mean that those who were appointed are not going to take up these positions?
And what's the role of the CJ, newly
in all of
appointed
this?
CJ?
You see, I could have, until the time this has been done, I've been a serious supporter of all or none. All right? But remember, sometimes, you can talk about all or none, but now when gazettements have been done, remember the interest now turn to the individual judges, because they also have interest. These persons who have been gazetted also have interest. So we must consider the question, where will they lie? The question is, do we wait and fight for all of them together, or do we continue to fight for all to be gazetted? They have been gazetted some, but we must continue fighting for all of them to be gazetted and ensure that the process is properly set out, so that in future, even as we go on to the constitutional amendments that we have been clamoring for, these are the areas we are recommended that the president should remain ceremonial and the ceremonial function be clearly spelled out, so that we don't have these issues of where there is a lacuna and then it is exploited by the executive, because the timelines have not been set out in the constitution within which period the nominations must be accepted by the president. That is a recommendation that must be done, so that if the constitution clearly sets out, just like in the bills that are sent to the president from parliament, he must accept or reject them within 14 days. And we're saying in terms of the judicial appointments, he must do so within a specified period, because you see, there is no time frame set out. So nobody can tell him do it tomorrow. An issue that now
Kelvin,
must be
what did we
clearly.
learn? What did we learn from the last time the president refused to appoint? How did that play out? And eventually, what is it that drove him to appoint all the judges?
No reason given.
No reason
he finally
given.
accepted to appoint.
Kelvin, let me ask this question. When you talk about boundaries, because I'm hearing boundaries, the discussion of the president can do this, cannot do this, and then you talk about there not being in our constitution a time frame within which he can do this. So just on that alone, how then can he be faulted if there's no time frame?
You see, that's what the judiciary has read into it, that once the recommendation has been done, he must appoint. But there is no,
Really?
there is no time frame within which he can do it, and that's what he has exploited through and through.
So from where he's coming from, he did what he was supposed to do.
No, but the argument has been that he's been breaking the law, and already, legally speaking, he hasn't broken the law because there is no time frame that binds him to actually accede to what had been suggested by the JSC.
Even though the conduct of the president is guided both by the law and also by practice and the need.
What decisions the court can do is to direct that he appoints them. He cannot be told to appoint them within a specific period.
So there's a lacuna in law.
There is a lacuna there because there is no time frame given. And of course, anybody who knows that there is no time frame given, he'll always say, what is reasonable?
What are the scenarios then? What are the scenarios for the 6? And you know, these are very illustrious judges with very illustrious profiles.
What I can say, and the message that is being sent out is stressful. Remember, when as a president you say that 6 persons are not suitable to become judges, and these persons we are talking about are already serving judges of the High Court. They're already, right now, they're on the court list as we're speaking. They're dispensing justice. So what message are you sending out to Wanjiku?
But Kelvin, remember, from the perspective of an officer of the courts like yourself, it is clear what the thinking is. But what do you think the thinking of the executive is? Because you're talking about politicians. You're talking about a process that they have a say in.
But CT, there is separation of powers. There is separation of powers.
Look,
this is the issue of separation of powers.
So what is the message, Kelvin?
The message being said is that to anybody else, including those who have been left out, is that if you make any decision against the executive, we'll deal with you. I think that is the simplest way I can put it.
Exactly.
If the executive is not happy with you, then they'll have to muzzle you up.
I think differently, and this is what I'm thinking. Those of you who are purveyors of the law, in whatever station you are in, surely if you understand our constitution as we do, and you knew that there was this lacuna, as you now clearly admit, why were steps not taken to ensure that it didn't exist? So that when we're talking about the president breaking the law, there's no wiggle room. Here, there's wiggle room.
Let me tell you, my brother, that you know, when a time frame is not set out, then it means that you must do it immediately.
Yes.
It does not say you hold back. Now, the unfortunate part of it is that this has been exploited, and the courts have made pronouncements that you must appoint. Once a constitutional court has made a decision, it means it is law. And then you must comply with it. So there is no question saying that now, I thought there was no time frame.
Actually, but there isn't a time frame, Kelvin. This is the point I'm trying to make.
Yeah, but the point that you're avoiding or ignoring, CT, is these are competent judges. We are short of judges. These are people who Kenyans need to serve them. So in whose interest is the president making this decision?
I'm trying to tell you
there's
that
a conflict of interest,
not only that Kenyans need to serve them. And let me give you this analogy. Maybe we can come to an understanding with what is at stake. If the president thinks that these 6 are not suitable, the first thing is that they should not be serving in the bench, because they're already serving. So you cannot tell anybody that you don't have an issue with this when they're already serving, dispensing justice. The Judicial Service Act and the Constitution provides that if there is any issue about a judge, the president can recommend the appointment of a tribunal. And that is a constitutional provision. But in the absence of that, then he cannot, if it was a lawyer outside here who is not subject to the Judicial Service Act, who cannot be subject to the JSC, that's something different.
Okay.
But we have a serving judicial officer.
I think that message is clear.
And a serving judge.
I think the coming days are going to be very interesting in terms of how this is going to play out. And I think that those vested, Kelvin, in the process will definitely have a lot to say. But if this decision where we are looking at it now has been made, I think if there's any...
We're just following precedent that, previously it has been done like that. The president has split the appointments and the judiciary accepted that. And that is where the problem was. We had hoped to avoid that so that the president is not set.
And yet here we are. Kelvin Mogeni, who is the chair of the International Community of Jurists, thank you for joining us in the Situation Room this morning. Asante sana.
Thank you.
Thank you.